Para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
There's Bomai? Judgment.
Yes.
Judgment. We'll read Bomai here. You have extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bomai, of course.
Yes, I purposely did it, Mala, so that otherwise you'll have
we don't have to go back and forth at all.
You've extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. You're now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. So the governor is recognized. I'm sorry. And this intra-party quotation is from Sarkari Amalat. It is adopted by Bomai. And it is consistent with those propositions, Malats, that I read to your lordships of Sarkari Amalat adopted by Rameshwar Prasad. So you can't enter into an moment you say, okay, I'll recognize these 3 people, I will entertain these 2 people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayagram regime. A legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House unless he is prepared to forego his membership of the House.
Mr. Sibal, the only problem is, I'm just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue, the government has to continue. It's basically reduced to a complete minority probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaz. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaz? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your Lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, So we are not against the floor test. We're against the considerations on the basis of which the floor test was ordered. This court cannot say that you cannot decide, or I give 10 more days or 10, 15 days. That's not the part. That's not the function of the court. Well, that's a. Now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the government, elected government, was toppled. The Speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue, and there cannot be any Kitemek order. Then, whereas in the present case, the decision to hold the floor test was taken by the governor on 28/6, by which time this honorable court had already interdicted the disqualification proceedings against the respondents on 27/6. The governor, being aware of the pendency of the disqualification petitions and being aware of the fact that this honorable court had extended the period of filing a reply on 2012, could not have disturbed the status quo in the assembly by directing a floor test. Para 82 of this honorable court noted, nothing prevents the Speaker from taking a decision either on matters of resignation or of disqualification despite convening the trust vote. Even in Shivraj Chauhan, your Lordship said, because there was no interdiction there. So the court said, in Shivraj Chauhan, the Speaker could easily disqualify. But in this case, what happened? The Speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? The illegality of the governor's decision on 28/6 cannot be remedied by subsequent event or actions. The respondents have sought to justify the governor's decision, dated so and so, by relying on Uddhav Thackerey's resignation on 29/6 instead of facing the floor test. Further, it has been contended that even the votes of 42 MLAs were excluded. We are still through. That's not relevant. When Bomai was decided, and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your lordship. That what Bomai said was the acts that have happened in between can be validated by the court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the Chief Minister Mullahs by setting aside the order of the governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your lordships decide one way or the other. Anyway, Mullahs, I'll just quickly now. Then Mullahs, kindly come to 46. S.R. Bomai and Union, the court, while considering the legality of a presidential proclamation under 356 that has been subsequently approved by both houses of parliament, held that an invalid proclamation would nevertheless have to be set aside. So this argument, that is according to an argument of frustration, because you are now saying, look, subsequent events have happened, I am the chief minister, I am enjoying the fruits of power, please don't do anything. Now there is confidence in me in the house, all irrelevant. Bomai says so. Held that an invalid proclamation would nevertheless have to be set aside, thereby recognizing the principle that the legality of an act must be tested on its own terms, and acts consequent thereto cannot give the color of legality to an action which is illegal. I've given the paragraphs, Mullahs. Further, Bomai holds that upon invalidation of the proclamation under 356, the natural consequence is to restore the status quo ante. Court may, however, mold the relief in respect of subsequent acts, but when restoring the status quo ante, the court must restore the Council of Ministers and the Legislative Assembly as they stood on the date of the issuance of the proclamation. Otherwise, the remedy of judicial review would be rendered meaningless. How much more eloquent can the court be on this matter? In fact, Bomai goes on to say that holding of fresh elections can also be injuncted on the principle that such a relief is to prevent the frustration of the constitutional remedy. It further goes on to say that the court may be duty-bound to give an interim order of this nature to make effective the constitutional remedy of judicial review and to prevent the emasculation of the constitution. Well, what's the point, Millets, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? Additionally, Millets, it is settled law that the village, let's leave that out, Millets, So, Millets, para 52, the legality of the governor's decision has to be determined with reference to the decision itself, not by reference to any subsequent events or facts. There is no constitutional basis for the proposition that the otherwise illegal decisions of the governor can be justified by referring to subsequent events and actions, including the fact that the petitioner participated in the floor test on the 4th of July. Then governor's decision on 30th of June to swear Eknath Shinde. That's the next. It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party acting dehors the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the election commission. The leader is as communicated to the election commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Millets. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackerey was the leader of the Shiv Sena political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the Shiv Sena legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as a leader of the Shiv Sena political party.